Champagne versus Wayne Champagne.
For the record, this matter is before the court on the defendant's motion for an order to show cause directed to Attorney Eric Chappell. Why Mr. Chappell should not be held in contempt and sanctioned for his alleged issuance of a subpoena to an employer, to an alleged employer of Mr. Champagne, contrary to an order of Judge Lohmeyer, going back to please. February 23rd, 2022, which Judge Lohmeyer issued a written order that any subpoena of an employer must be signed by the court. Anyway, this hearing is being conducted via Zoom. Present is the defendant, petitioner Wayne Champagne, as well as Attorney Eric Chappell. Good afternoon, everyone.
Good afternoon, Your Honor.
Good afternoon.
Mr. Champagne, the court has read your motion thoroughly. The court has also read and reviewed the response of Mr. Chappell. Is there anything you want to add to your motion, Mr. Champagne?
Well, first of all, I didn't get a copy of his response, so I thought that was the way the courts worked. So I don't know what his response would be. This is what Mr. Chappell's been doing to the courts. He tries to confuse me. I don't never have a defense.
Hold on, just a minute. He tells us that he mailed it to you on November 16th. That was last Thursday. Is that still your mailing address?
That's correct, Your Honor.
Okay. Do you want Mr. Chappell to email it to you right now?
Sure.
Go ahead and give me your email. So it's Champagne Construction.
Champion, the same person you.
I'm sorry. Yep.
Yeah, the subpoena you sent got the correct email address.
Champion Construction.
Mr. Chappell, on your response, you do reference that same email address, so it seems to be a valid email address. What if the court puts this more to 215? We'll give Mr. Chappell an opportunity to scan it and send it to Champagne. Mr. Champagne will have a chance to review it.
I appreciate that.
215?
Yes, I'm going to set right here. I appreciate that. Thank you.
Yep. Thank you, Judge.
Back in it.
So I'm back in.
Champagne versus Wayne Champagne.
And this is before the court address a motion for order to show cause directed to Attorney Eric Chappell for issuing a subpoena allegedly contrary to an order of Judge Lohmeyer's going back to February of 2022, in which she ordered that any subpoena of an employer must be signed by the court. Both parties have returned. Mr. Champagne, did you receive the response of pleading filed by Mr. Chappell?
Yeah, it's rather lengthy, so our computer is not keeping up with it. But I don't want to stall on that. He admitted in number 5. I read that he did subpoena it, and he wants to blame somebody at his office. So I'd like to give you the floor. Everything I hear about your courtroom is your fair. So I'm going to let you make the decision if Mr. Chappell violated. He's admitting it. So let's just go on with it.
Well, I'm not sure if he's admitted it. He admitted issuing a subpoena to an entity by the name of MRD. And Mr. Champagne, you are self-employed, is that correct?
Yes, Your Honor, I am.
Okay, so MRD is not your employer if you are self-employed.
I have contracts with them. Yes, they are my employers. I receive a check from them. I
Hold
work
on.
for them.
So they direct your hours and the time frames that you work. You get it. They issue a W-2 to you.
No, I get a 1099 from them.
That in case of court, you are an independent contractor. You are not an employee of MRD unless you could show otherwise. An employee is a person who is under contract with the employer, and and that the employer controls and directs you in the material details of how your work to be performed. So everything I've read throughout these pleadings, you are self-employed. MRD is a contractor. Yes, you have contracted with them. You do work for them, but they are not your employer from a legal standpoint.
Can I say something, Your Honor?
Okay, I thought I gave you the opportunity, and you said you gave me the floor. Mr. Champion, give me the floor right now, and then I don't want you to interrupt me. Okay, so go ahead.
Okay. Well, first of all, this is what Mr. Chappell was doing. So MRD has reached out to me and they said, listen, if your court proceedings are not over, you're no longer going to gain employment with us. Okay. So maybe the technical wording isn't what you wanted to say or what it should read, but one way or the other, Mr. Chappell, he just cost me.
Judge Lohmeyer issued the order. If you disagree with that language, you should have addressed that to Judge Lohmeyer back then.
Well, I didn't expect to be treated fairly today. I haven't been done yet, so I don't know. So Mr. Chappell can subpoena anybody he wants. He's going to put me unemployed. He's not even doing a smart decision, Your Honor. He's trying to get me in jail. If I don't keep a job, I can't pay my obligations. Why is he harassing the people? I don't get it. I wasn't a friend of the court. I suffered a rib injury. I brought my paperwork in there. I explained to him I was behind. Mr. McKee was fair. He's the only person who's treating me like a human being in this courtroom. Nobody seems to care what Mr. Chappell is destroying my character, my lifestyle. Our divorce is over. Mrs. Champagne is not suffering. Montana's not suffering. She's at my home right now, Your Honor, right now. I was given 80 days to see my child last year. You know how many nights, overnights I had with her? Over 200. Over 200 nights. The child lives with me. Okay, so Mr. Chappell is going to keep on messing with me until I can't get employed by anybody. Or you want to say self-employed. Excuse me for saying that, but I've had 25 people call me and say, if you don't get this attorney off my back, you are no longer going to work for me. I can fill your courtroom with these people. Nobody seems to care what this guy is doing. Nobody. And you're already going to make excuses for him. I can say it again. Everybody said you're fair, but I'm not saying it. Nobody has treated me fair in this courtroom since day one. I'm divorced. I want this guy off my back. The front of the court had an issue with me. They could have brought it up. He gave me an opportunity to make my payment, get caught up on the rears, and guess what? I done it. I had to borrow the money. Mr. Chappell wants to show you I made $490,000. You just said it yourself. My guys that work for me are self-employed. The money comes to me and I pay them. If they don't work and I don't get contracts because he's messing with them, I'm done. You're going to throw me in jail next month because I'm going to violate again. He's going to blame on his, I seen it. He says, Amy drafted the letter up, the subpoena. He didn't know it. So he's backpedaling already. And you're saying that you got an out for him because I'm self-employed. So he can subpoena anybody. But Judge Lohmeyer, so she technically, maybe she used the wrong wording, but you could ask her. I'm sure she knew what she was thinking. She said, exactly my case I pleaded back then. Is that I said, Your Honor, I'm losing my jobs. My clients are calling me. They don't want this monster in their books. They don't want him after him. You know, there's something way bigger going on in this case than Mr. Chappell. I'm telling you right now, I got pictures to prove to the courts. He goes to dinner with my ex-wife. My kids ride in Mr. Chappell's vehicle. I'm telling you what, this is sick. The man is a monster. He should never, ever practice family court. Because I'll tell you what, he doesn't do anything for families but destroy them. Destroy him, destroy him, destroy him. And you, that's who I'm talking to, right there. You are a bad person. And you know what?
Wait, Mr. Champagne, hold on, Mr. Champagne.
You go ahead. You keep
crossed the
on
line,
doing
Mr.
what you're doing with
Champagne.
her. And she's going to get you too.
Mr. Champagne, if you don't stop and mute you, you're going to cross the line when you start attacking the other side. This court will not permit that. This is a civil court, Mr. Champagne.
Well, I feel like it's a criminal court, Your Honor.
Even though you're divorced, Mr. Champagne, this case is not over until you've satisfied your child support and spousal support obligation. I mean, those issues still outstanding. Till your child attains the age of 18, it's fourth order, and spousal support is paid. There's still an active case. Lori Champagne, your ex-wife, is obviously employing and paying Mr. Chappell to address these matters. If Mr. Champagne is not satisfied with the front of the court's response pushing to pay child support, then she can pay an attorney to pursue the matter.
Well, that's the question, Your Honor.
So that's also what happened. The court again has read your pleading story. I've read Mr. Chappell's pleading story. The court's opinion, MRD Apartment is legally not your employer, as you're self-employed. And due to the allegations that you had not paid any child support for the months of June, July, August, and September, I can understand why someone would want to take some action. And obviously, if Mr. Chappell would have contacted this court and say, Judge, I want to be on the safe side. I don't think it's an employer, but I want you to sign a subpoena. This court would have signed the subpoena. With someone that had not paid the diamond child support for the months of June, July, August, September 2023, this court would have issued that subpoena to MRD Apartments, even if it was your employer, Mr. Champagne. So the court determines that your motion for show cause should not to be denied, set aside. The court rules permit discovery. This court is too busy to be a gatekeeper and handle every issue about discovery. I am simply without the time to authorize, oversee, and guide discovery. Just don't put yourself in a situation where there's a significant arrearage, Mr. Champagne. There'd be no reason for Mr. Chappell to waste Lori Champagne's time and his time and the expense of his client to issue subpoenas if in fact things are being paid timely. But since this court is not going to authorize, oversee, and guide discovery, and discovery is permitted by court rules, this court will strike and eliminate the order of Judge Lohmeyer of February 23rd, 2022, that any subpoenas of an employer or subcontractor must be signed by the court. So neither of you needs to get this court's permission to conduct discovery. Mr. Chappell, if you can prepare an order, the court is denying the motion to show cause, and I'm also striking the provision of Judge Lohmeyer's order February 23rd that requires subpoenas of employers to be signed by the court. The court does not believe that's appropriate under Michigan law or the court rules that permits this discovery. So I sympathize with the situation, Mr. Champagne.
No, you don't. No, you don't. No, you don't. You know what? You guys had this set up before I even got in here.
All right, Mr. Chappell, you prepare the order?
Well, Your Honor, I'll submit it under the 7-day rule.
All right, do you have any other questions, Mr. Champagne?
I got a whole lot, but you're not the guy to answer them. You're almost as unfair as everybody else at that courthouse. And you tell you what, you guys are all going to go to hell for this. I'm finished.
All right. All right, that will conclude this matter. Your comments are noted, Mr. Champagne. Matters before the court this morning on the plaintiff's motion for order to show cause. This hearing is being conducted via Zoom. The president is Attorney Leah Worker, representing the plaintiff Jessica Fent. Ms. Fent is present. In addition, Attorney Derek Jocks is present, representing the defendant Daniel Fent. Is Mr. Fent present this morning?
He is not, Your Honor.
Okay, have you attempted to contact him by phone this morning, Mr. Jocks, either text him or phone him?
We have, Your Honor. I've not had contact with Mr. Fent since in court at the last hearing.
Okay, is it going to voicemail?
It does go to voicemail. He has not been in contact with my office at all.
I understand. So you did attempt to call him this morning, no answer. He will not answer. Is that correct?
That is correct, Your Honor.
All right, Ms. Worka, you're alleging that the defendant failed to provide the notarized financial statements to you by noon October 30th. Have you received that since filing your motion?
I have not, Your Honor. I've not received anything.
All right, Mr. Jackson, isn't that something you do typically when you're retained by divorce clients? You prepare the notarized, the financial, the required financial information forms when you conduct an intake.
It is standard practice that we provide those. It is standard practice that we provide those forms upon being retained by a client under certain circumstances. When clients do not provide those forms back to us, we attempt to get them to provide the information, the documents they're required in certain circumstances. When they're not provided to us, it causes issues such as this one. As I explained after the last hearing, I have not had any contact with my client whatsoever, despite numerous phone calls and emails. So I'm not aware one way or another whether or not he's provided the documents correctly to Ms. Worker's office, but I'm going to take her for a word when she says that they were not provided to her office by the time and date that was provided in the previous order. And I do have a standing motion withdraw from the case because of the lack of communication with my client.
So I'm trying to understand. So do you have those documents in your possession? Did your client sign anything? Provide them?
I do not. No, not this time, Your
so
Honor.
Your client never responded to you and provided you with the requested documentation. That's correct. So you had nothing to forward to Ms. Worka.
That is correct, Your Honor.
All right, Ms. Worka, you're requesting. You're obviously asking for some costs. That appears to be appropriate.
That's correct, Your Honor. We had requested a total of $545 for the motion to compel. That issue was reserved. The breakdown of that was $525 for attorney's fees, 2.1 hours at $250 an hour, plus a $20 filing fee. I'm also asking for costs for the show cause, which would be $645, which includes the attorney fees and the $20 motion fee as well, which would be a total of $1,190. We are not able to.
Your out-of-pocket costs are a $20 filing fee. Is that correct?
Yes.
Two of them.
Two of them.
To compel. So you had $40 in out-of-pocket costs.
Correct, Your Honor.
All right. Mr. Jocks, response? Any response? Obviously, it's difficult when your client's not here.
Unfortunately, it happens when clients don't comply with court orders and time is expelled by opposing counsel that things like this happen. I really can't give a good response to that, Your Honor. I don't think that the cost that Ms. Work has placed on the record are unreasonable given the circumstances.
Very well, the court will award to Attorney Worka costs and attorney fees totaling $540. That's $500 in attorney fees, $40 in out-of-pocket costs, total $540. The court will order that Mr. Fent pay that to Mr. Worka by December 15th, 2023. And Mr. Jocks, your motion to withdraw was filed on Monday, 2 days ago. It's not noticed for hearing. The court will address that on December 4th at 1:30. We'll put over a docket December 4th at 1:30. I want you remain involved in this case to see whether or not Mr. Fent will appear for that mediation on December 4th at 1:30. So we'll leave that on just to see whether Mr. Unless you have other thoughts, Mr. Work on Mr. Jocks, we need to get Mr. Fent here. Again, do we want the mediation will be, you can't proceed without financial information, correct?
That's correct, Your Honor.
So do you want to vacate that? Yeah, otherwise I can enter an order that he personally appear on that date in front of this court.
I think that would be my preference, Your Honor. I don't know that we can have a mediation on the 4th, and I know that scheduling with the court for mediation, those time slots are, I would hate for that to be wasted. However, at the same time, my client is wanting to move this matter forward.
Okay.
Mr. Fent is not cooperating.
Okay. With respect to your order, Mr. Jocks, you will have to amend your proposed order to include the last known mailing address for your client. Any orders to withdraw, the court needs an address to which future notices can be mailed. So
We
if
can
you
do
if you
that
want
over
to
here.
submit a revised proposed order withdrawing, which just includes a sentence at the end, defendant's last known address for mailing purposes for future notices, such and such, and then the court would be inclined to enter that order on December 4th at 1:30. So the court's going to issue an order directing Mr. Fent, and I don't know, can someone provide an address for Mr. Fent? His last known address, is there a marital home?
Yes, Your Honor.
Is that the 437 John?
Yes, Your Honor.
All right. Is that your last known address as well for your client, Mr. Jocks?
It is, Your Honor.
All right. So, Mr. Jocks, you don't need to be prepared for mediation or do anything. Just appear on December 4th at 1:30. Reach out to Fent. Let him know he's got to appear on that date. He failed to appear today. And if the court's going to issue an order to show cause, directing Mr. Fent to personally appear on that date and time in this courtroom, then he can go down and zoom in for the mediation. Mr. Walker, hopefully he's got the information. But we've already got that date set. It may have to be canceled if, in fact, Mr. Worker cannot, if Mr. Fent does not provide the documentation by then.
Your Honor, if I may, regarding, I ordered the 400 and I believe it was the $45 for the motion to compel regarding the show cause order, the fees for that. The
I thought you said there were two $20 filing fees, motion to compel and motion to order show cause.
That's correct, Your Honor. But the total attorney fees and the filing fees, the total was $1,150.
I understand the court's awarding $500.
Okay, thank you.
$500 attorney fees, $40 cost, total of $540.
Thank you.
I'm sorry if I misstated. $540 to be paid on before December 15th. Can you prepare an order to that effect, Ms. Worka?
Yes, Your Honor.
And also include the order that the mediation will continue on the schedule December 4th at 1:30, which time the court will consider defendant's motion to withdraw. So it should be real quick, Mr. Jacques. Are you available on that date and time? Just to appear briefly, and I hate to keep attorneys on board, but this time I'd like to see whether if we can, the court needs your assistance to try and get Mr. Fent to at least appear on that day. So if you can get another letter out to him, tell him this mediation is still on for December 4th. The court would appreciate that.
I believe the mediation for that date is still on my calendar at that time.
But he can reach out to Mr. Fent and remind him of that. There needs to be present for that. And the court's going to mail a separate notice or show cause that he personally appeared in this court on that date and time.
That should be an issue. Would I be appearing via Zoom at that point, Your Honor?
That's fine. Yes, correct.
Okay. No, it should be an issue. It's already on my calendar then, Your Honor.
All right.
But I will provide him additional notice as well.
Thank you. That's all the court's asking. Good morning, Ms. Brower.
Good morning, Your Honor.
I think Mr. Worker will prepare the order in this matter, so we're all set on that.
Okay.
Thank you. All right, that concludes the matter. You can all zoom out.
Thank you, Your Honor.
Thank you, Your Honor.
It's now session on page 1, Amber Gensler versus Paul Gensler.
For the record, this matter is before the court on the plaintiff mother's objection to a referee record order. Parenting time be modified to grant to mother additional parenting time on alternating weekends. Any event, this hearing this morning is being conducted via Zoom. It appears both parties are present. Amber
Yes.
Howells, formerly known as Gensler. In addition, defendant father Paul Gensler is present. Good morning, both of you.
Good morning.
Good morning.
The history on this is Ms. Gensler, after the two of you were divorced, you moved to the state of Colorado, but now you've returned back to Monroe County, state of Michigan. Is that correct?
Yes.
Okay, the two of you have conferred with the front of the court this morning, who has provided the court's final recommendation. The recommendation is that referee recommended be adopted and modified, namely, mother shall have additional parenting time as the parties can agree. If the court recalls, the recommendation was Fridays at alternating weekends, Fridays at 6 to Sundays at 6. Summer parenting time as previously ordered. Ms. Howells, do you understand the recommendation this morning?
Oh, yes.
Do you have any objection to the court adopting this recommendation?
I would like more time, but I suppose I need to be here in Michigan more before I can get more time with the children.
Well, the best parenting time schedule is one that you and Mr. Gensler can agree upon. You know, each other's respective work schedules and the children's schedules. The children are 14 and 12 now. They presumably are involved in a lot of extracurricular activities. And obviously those activities are important. Obviously, if they fall in your parenting time, you should make sure they get to those activities. You don't want to disrupt those activities.
No.
So you're not opposed to the court adopting this recommendation at this time. The court you can always come back and ask for a very specific schedule if the two of you cannot work through things together. You understand that?
Yes.
All right, Mr. Gensler, what's your position on this recommendation that the court adopt the referee recommend ordered and mom shall have some additional parenting time as the two of you can agree? Mr. Gensler?
I'm in agreement with that. That's fine.
Okay. So,
Yes.
Mom, have you in fact settled in Monroe County, or you're still in transition, or you seem to suggest that once you spend more time in Monroe, then the issue can be further addressed. I'm not sure what you meant by that.
I just, I don't know. I guess maybe if I'm here longer, because I know that I was out of state for a long period of time, maybe if I am in Michigan longer, then I will be able to get more time with the children other than alternating weekends.
Okay. That was one of the questions the court had, is how long have you been back in Monroe? A couple months?
My current husband and I and our daughter just moved back the end of July.
Okay. So you've been there about 5 months now, 4 or 5 months?
Yes.
And the reality, the two of you, the children old enough now, they're going to dictate a lot of the parenting time schedule. Sure, they're minors. It's not their call. But the reality is, when the children says, Dad, I want to do this with Mom, and obviously you don't want to work behind each other's back. You need to make sure on the same page. They're not the children. You don't want the children, they're not driving the bus here. But to the extent that they express they want to do this with Mom or whatever, or this with Dad, then obviously you should be cognizant of that. Both of you should be involved in their scholastic activities and their extracurricular activities. So the summertime previously ordered is basically Dad has the first 3 weeks and last 3 weeks of summer. Mom has the bulk of the summer, correct? Or the middle part of the summer, is that correct?
Yes, our summertime is equal. We both get 6 weeks.
Okay. Well, once again, the court reiterate the best schedule is one that you can work out together. So be flexible with each other. The children are growing up quickly. So give it a try in terms of just communicating, in terms of being flexible about it. Obviously, it's still important that each of you make sure that the children have something for the other parent for Christmas. That means a lot to the children. Dad, you take the kids out. Okay, we're going to focus on, I want you to get something for your mom for Christmas and take them out shopping. And same with you, Mom. Make sure they get something for Dad for Christmas. And those little things mean a lot to the children. Right. Is there anything, the court's inclined to adopt the recommendation? I don't hear any strong objections. Anything further, Ms. Howells?
No.
Okay, give it a try. And obviously, the front of the court holiday schedule presumably was adopted previously. So you're all set for the holidays, Thanksgiving, Christmas. Is that correct?
Yes.
Okay. All right. All right, if there's nothing further, the court will adopt the recommendation. If in fact communication is not working, you can always petition the court, Ms. House, for a more specific printing time schedule, or expanded printing time schedule.
Okay.
All right, the court will adopt the recommendation. The copy will be mailed out to both of you. And that will conclude this hearing. You can both zoom out. Have a great Thanksgiving.
Court is now in session. Top of page 2. Jennifer Wallach versus Bennett Rhodes.
The record of this matter is before the court. To address the ex parte order entered by this court on October 11th, 2023, which suspended plaintiff mother's parenting time. The matter was adjourned from October 31st so that the plaintiff mother could consult an attorney. This hearing this morning is being conducted via Zoom. Present is attorney Matt Vidido, representing the defendant father, Bennett Rhodes. Mr. Vidido and Mr. Rhodes are present. Is Jennifer Wallach present on audio?
Yes, sir.
Okay, good morning, Ms. Wallach.
Morning.
The parties have conferred. Good morning, Ms. Andrus. The parties have conferred with Ms. Andrus this morning, and the recommendation is that this matter be adjourned once again to January 30th, 2024 at 9 a.m. so mother can talk to an attorney and to begin supervised printing time at Family Counseling Shelter Services. Mr. Vidido, presumably this recommendation is to be with your client. Is that correct?
Yes, Your Honor, as long as the current order remains in full force and effect.
It would. Ms. Wallach, do you understand the recommendation this morning?
Yes, sir.
Have you conducted the intake with Family Counseling Shelter Services?
No, things have been being sent to the Newport address, and I'm a Washtenaw County resident. So when the papers were served for the original court date, it was served right here to Washtenaw County. They're telling me to change the address with the friend of court. I was not aware that they didn't know about this address because this is where the papers were served by the private investigator.
Okay, have you provided the friend of the court with a current mailing address?
I'm going to do, she just told me to do that, and then I got transferred back over to you on audio. So I will do that when we hang up. Yes, sir.
Well, let's make sure that a copy of this comes to you. What is your current mailing address?
300.
All right. Ms. Anderson, did you note that address for mailing purposes?
I did, Your Honor.
That appears to where she was served with this order. So the circuit court fund will pay for the intakes. Do you have the phone number for Family Counseling Shelter Services, Ms. Wallach?
I was asking her if I could do this out of Washtenaw County, and she said no. So that's the number I have. If you could give me that number, that'd be great.
Okay, Ms. Anders, could you and actually maybe provide that in this phone number? You can verbally provide that to Ms. Wallach so she perhaps can call today.
0180.
Okay. If you could add that to this recommendation, Ms. Anders, so at least it's in writing for the benefit of the parties.
Yes, Your Honor. I know that plaintiff was requesting to not have it at Family Counseling and Shelter Services and have it in Wayne County due to her having no transportation or money. And again, that's why it was adjourned. Or she requested to adjourn it to retain counsel through legal aid.
Okay. There's actually Washtenaw County. I think she wants to do it in Washtenaw County as opposed to Wayne County, Ms. Anders.
Yes. Washtenaw.
I don't know why that cannot take place. If you can find an agency that will provide this, it's just that this court will not pay for the intake. So I don't see any reason why you could not. If you can find an agency up there that will provide, we just want to make sure that your 6-year-old child is protected. And so we want to start with some supervised parenting time. So if you can find an agency that will do that, Ms. Wallach, it's just a matter of reaching out to Attorney Vidido. And Mr. Vidido, you would have no objection to that. Obviously, we need a transportation issue. Mr. Rhodes presumably lives in Monroe County. But obviously, if that will make it work, the court's not opposed to it. Your thoughts, Mr. Vidido?
Your Honor, I think that she's indicated today that she doesn't have adequate transportation. I know that would put the brunt of those visits on my client, making sure that the minor child got there. But I think you'd have to do that anyway if they were here. It'd obviously be more convenient here. But if she finds an agency out there, we just ask that it be at her expense and not at my client's expense.
Well, we're talking about once a week. I mean, obviously, I think Mr. Rhodes would want his son to have some contact with his mother. I mean, the court would be inclined to order that if, in fact, he refused to do so. Just to make it happen once a week. We're not talking about a 3-hour trip. We're talking maybe a 40-minute drive. So, okay.
Your Honor, I understand that. I guess what I'm saying though is that while Miss Wallach has indicated that this is the case, she doesn't have adequate transportation. She lied to the court the last time we were in court. And so I don't want to necessarily take her at her word because she's already been dishonest during the last proceeding. So I'm just stating that reservation on the record.
Okay.
And I ask how so? I mean, I've been as open as I possibly can.
And in what fashion was she untruthful with the court, Mr. Vidal?
Your Honor, one of the concerns that we raised in our motion was that she had left the minor child, and she indicated on the record that she left the minor child with the child's uncle, and that is not the case. She left the child with her ex-boyfriend. That's a falsehood. And there's another one that I have here noted, but she also indicated falsely to the court that my client was supposed to have supervised parenting time, and the court looked through the record and found no such order. So I don't want to rely on her representations as they've been dishonest in the past.
All right. Thank you, Mr. Vidal.
May I reply to that? The gentleman that Dakota was left with is he's been known to be Uncle Alvin since the day he was born. That is lived with all three of us together. That gentleman drove us to the hospital to have him born. He's been there every day of his life. He knows that man as Uncle Alvin. He has been raised to know him as Uncle Alvin. And Bennett still takes him over to Uncle Alvin's every weekend, Saturdays usually. So that is not a lie. If by blood, is that his uncle? No. Does he know him 100% as Uncle Alvin? Yes, and since the day he was born.
All right. It's noted, Ms. Wallach. But you can try to reach out, see if you can find an agency in the Lenawee. They may not do that because you're not this case is a Monroe County case. Mr. Vito, is dad getting the child to school every day?
Yes, Your Honor.
Okay.
Yeah. Oh, I know. I just saw the.
All right. Was mom, before the ex parte order, was mom's parenting time occurring in Monroe County, or was it occurring in Washtenaw County, Mr. Vidal?
It was in Monroe County, Your Honor.
Okay, so mom has just recently moved then from Monroe County to Lenawee, or to Washtenaw County, correct?
About 4 months ago.
Oh, 4 months ago.
4 months ago now.
All right. All right. Is there possibly, what about some, the court obviously is concerned about this period of time where the child has no contact with his mother. We have holidays coming up. What about some time for Christmas? Is there a family member that can supervise a couple hours on Christmas or the day before Christmas, Mr. Vidal?
Your Honor, she hasn't even made the entirety of her FaceTime visits with the minor child through FaceTime. I think that it's important that we just stick to the order that the court previously issued. And as she didn't take the initiative to contact Family Shelter Services, she could have looked that up. She says she wasn't given the written order, but I mean, she's Dakota's mom. The court shouldn't have to spoon feed her to make sure that she's meeting her obligations to the child.
All right, court does not disagree. Ms. Walk, how come you didn't take advantage of the court's order that you have FaceTime with your son on Wednesdays and Saturdays at 6 o'clock?
So we did doing the FaceTime.
I'm sorry?
We have been doing the FaceTime on Wednesdays and Saturdays.
I'm not sure. It's not a real clear audio signal. Can you repeat what you just said?
I have been doing the FaceTime with Dakota on Wednesdays and Saturdays.
I'm sorry. The question is why not?
No, I have been doing them.
Oh, you have been.
I have
All
been
right.
doing the FaceTime.
All right, Mr. Rhodes, what about that? I mean, has she been FaceTiming your son? You're muted, Mr. Rhodes.
November 4th appointment.
I'm sorry?
She missed her call on November 4th.
Okay.
Other than that, there has been FaceTime contact.
Okay, so there has been. Is there anyone in Monroe County, an aunt, an uncle, sister, Miss Wallach, or you, Mr. Rhodes, that can supervise to give mom some time for the Christmas holiday?
There's my mother.
Ms. Walk and Mr. Rhodes and Ms. Ritter, I'm gonna have you talk with Ms. Andrus to see whether you can agree upon maybe a couple hours for mom to have contact with the son supervised. If you agree upon a supervisor, if not, the court will address it. I'm gonna have you talk with Ms. Andrus once again briefly. If you can't come to agreement, then the court will address that. The court would like to see some limited supervised spending time for mom for the December 24th or 25th.
Also coming down for Thanksgiving.
Your Honor.
I'll listen to the argument in a minute, Mr. Ritter. I'm gonna have you talk with Ms. Andrus, see what you can agree upon a couple hours for Christmas. If you can't, then the court will determine that.
Understood.
All right. I'll take care of another matter. Put you back in the breakout room.